say that sir had removed. Okay, this is the technical problem. Sometimes it happened. Yes, thanks everyone. And it is my humble request. If documents is not showing or if there is no recording on, please inform me. Okay, because it happened that several friends are living in the remote area and sometimes they are unable to join the live classes. If recording will be available with the PDF file, it will be grateful. It will be very helpful for them. That's why for the benefit of other friends, you please always inform that sir, recording is off, or video or document is not showing. This is the so on. Please come to the class. A good afternoon to all my dear friends. As you know that I am going to take second class in the proper manner, and that why in the previous class I discussed you one question that was the 2000 DU LLB 2010, and question was that what are the elements, what are the essential ingredients of the crime. Today I am going to discuss another case, another question which had been asked in the previous year. That is the explain the common law principles. That is the maxim of the actus non facit reum nisi mensit rea. And we have to discuss also exceptions of this topic. It means there are two parts of this question. First part says that please discuss the rule, and second part talks about the exceptions. That's why, my dear friends, I am going to discuss first of all the rule, and after that I will start the exceptions. As you know that I am taking the two classes I am taking the classes in two sections, and sometimes it may be I may confuse that from where I have to start. Generally, if you feel any inconsistency, if you get any inconsistency, please inform me. Normally, I am going to start the class from this rule. What is the rule? Rule is that actus non facit reum nisi mensit rea. And for the competitive exam, especially in UP, Bihar, Jharkhand, these questions had been asked in the several times. Question is straightforward. Question is simply that discuss the actus non facit reum nisi mensit rea and its exceptions. And this is the most important. You can't get these questions in the any books. The point is that concentrate here. As you know that I had already told you that this maxim was developed by which court? By the common law courts. As you know that in the earlier in the England there were two types of courts. One was the common law courts and other was equity courts. And this case, these maxims had been applied and discussed thoroughly by which courts? By the common law courts rather than equity courts. Okay. As you know that if you go in the interview, they always ask similar types of questions. That's why which court had developed this maxim? That is the common law courts. First question. Sorry, first answer. Who has developed this? Who has evolved this maxim? The Honorable Justice Coke had discussed these maxims first times. Who had discussed further? As you know that Lord Kenyon had discussed this maxim thoroughly, and he clearly wrote that actus reus and mens rea both are essential of commission of crime. It means in the case of Lord Kenyon, Fowler versus Hazard, these questions, he clearly said that there are two essential ingredients of the commission of crime. My point is that although here this is the literal line, same meaning, but once you are quoting the name of the case, name of the judge, name of the jurist, in that case of course you will get much more marks. Okay, because whatever you are saying, for example, I am saying that there are two parts of the actus non facit reum nisi mensit rea. First is the actus reus, second is the mens rea, but I am not authentic source. Who is the authentic source? Authentic source is Lord Kenyon, because he was the justice, he was the jurist. That's why my humble request that please at the time of writing the your answer always write literal meaning and opinion of the jurist. The Lord Kenyon. Do you know what happened? As you know that again I request you that please don't disclose each and everything, whatever is that. But answer is that In the previous semester, I was examining the copies. As you know that in the DU, getting the good marks is very difficult. Maximum students will be between the 50% to 60%. Only 5% or 10% students will get more than 60%. So be careful. Here the answer. Checking the copies, that is the something different things, as you know that. But what happened in the previous semester, when I was checking the copies, I out of 10 I put 9 marks, because that person had written the answer in a very wonderful manner. That's why how to write the answer, this is the perfect manner. And this is the point. Now come to the there here. You can also see, you can also write. It says that here the actus non facere. What is the rule? Rule is this part. Rule is the prohibited act and guilty mind. As you know that from the very beginning, when I was discussing the elements of the crime, I already told you that there are four elements of the crime. First was the human being, second was the guilty mind, third was the actus reus, and fourth was the injury. Among them, here we are going to discuss four ingredients of the crime. It says that rule is that a crime can't be committed without the prohibited act and guilty mind. As you know that in the previous class, I told you that what would be effect if this maxim will be applied, and what would be effect if this maxim would not be applied. This is the jurisprudential answer. If anyone is able to reply and he is writing the answer in the UPSC, do you know what is the difference between a UPSC exam and other exam? In the UPSC exam, they always try to search jurisprudence, why law exists, what would be effect if that law would not exist. In this way, they demand jurisprudential view of any writing. But in the PCS, in the judiciary, they demands only the remembering the words and remembering the bare acts. That's why this is the basic difference. My point is that this is the, if you are going to write in the UPSC, you can write here the jurisprudential point of view of this particular maxim. I am sure that you can't get these writing in any books. My point is that here, what is the benefit? What would be fact if maxim would be applied, and what would be fact if maxim would not be applied? This is the jurisprudential answer of these questions. Here, if maxim applies, once this maxim will be applied, of course, this will be benefit for the accused. Why this will be benefit for the accused? Because once suppose that it has been proved that he had committed the crime, but prosecutor is unable to prove that he had committed the crime with guilty mind. So what would be happen? Suppose that he was the unsound person, but he killed another person. Suppose that I am unsound person and I killed the Gurpreet. Whether I had committed the crime, it depends upon whether this maxim would be applied or not. If this maxim would be applied, I am an unsound person. And in that circumstances, in case of application of this maxim, I would not be convicted. Why? Because although there was the actus reus, but mens rea, my guilty mind was missing. In case of application of this maxim, a person of unsound mind can't be convicted, can't be punished. But suppose that there are certain exceptional cases, that is the other thing. But suppose that if this maxim is not going to be applied, in that circumstances, what would be happen? In that circumstances, a person can be convicted even without guilty mind. A person can be convicted even without guilty mind. What happened? I will discuss later on. There are several cases. One of them is that, suppose that there was a book, Lady Chatterley's Lover. Book का क्या नाम था? Lady Chatterley's Lover. As you know that in the starting point there was a huge cries over the morality. Huge cry over the morality. In that book there was nothing except there was a love story of the two persons. That was the one of the woman and other was the man. और बोलें कि इसको रहने दें. I think I can speak. It should not be so much limitations. What happened in that case? In that matter, age of the girl was much more, and it means a girl was older than the boy. In that matters, what happened in that book? On that book, say in several countries, ban was imposed. That was the starting point in this country. What happened in our country? That book was also banned. What happened? There was a bookseller. He was a bookseller. He was not knowing about the content of that book. He was not knowing about that book. He was not reading the newspaper. What happened? Fortunately or unfortunately, that book was available in his shop. Later on, he was prosecuted. He was prosecuted, and he was prosecuted. Why? He was prosecuted for selling the obscene book. He was prosecuted for selling the obscene book. He started to argue, my lords. I was selling, that was the actor, and I was the selling, that was the my act. But I was selling without guilty mind. I was not knowing about the content of that book. I was not knowing that that book had been banned by the government of India. It means he was saying that, my lords, there was no guilty mind. But what happened? That is some exceptional cases. That matter come under the exceptional cases. He was convicted even without guilty mind. So my point is that once a maxim would be applied, that seller can't be convicted because he was without guilty mind. If that this maxim would not be applied, in that case, that seller would be not convicted. Are you getting my points? Sorry, if that seller, if maxim would not be applied, that seller would be convicted. So my point is that this is the big disputes among the jurists whether this maxim should be applied or not. If applied, in what circumstances? If not applied, what are the exceptional cases? That's why this is the big point. Meaning of the mens rea. Here the meaning of the mens rea is that I had already discussed in the earlier classes. Meaning of the mens rea, that is the guilty mind. It can be shown by the several words. For the example, intention, knowledge, reason to believe, negligence, rashness, like this. I will later on discuss differences between intention, knowledge, reason to believe, negligence. Later on, I will discuss each and everything. Come to the point. What are the exceptional cases? In which cases this maxim would not be applied? Exceptional cases are the criminal libel, public nuisance, contempt of court, abduction, kidnapping, bigaming, waging war, sexual harassment, rape, like this. It means suppose that a person who had committed the rape without guilty mind, whether he should be convicted or not. Do you know, I had written rape first time. If you go and read any book, you can't get exceptions. You can't get sexual harassment, rape, these things as an exception of this maxim, because no one, if author is great, he will never try to write any disputed things. He will never try to write any disputed things. But once I will discuss rape law, sexual harassment, waging war, you can find out. Bigamy, you can find out. So my point is that here, whatever I had written here, these are the exceptional cases in which a person will be convicted even without guilty mind. These are the exceptional cases you can get. Here it is my suggestion that please purchase at least one objective book. For example, you can purchase of any objective book in which previous year question paper of judicial service exam, APO exam, other exams are available. If you solve that book, whatever chapter I am reading, I am teaching, in the same situation, you can prepare for the competitive exam as well as semester exam. I ensure that if you go to the coaching center, you will always feel, you will always miss me. My point is that at the time, purchase at least one objective guide, previous year question paper. Okay, in that way you can get. My point is that you can find out the some exceptions which have also been mentioned in this. Selling up obscene book, criminal commodities like this, these are the exceptions. Now I am going to discuss these exceptions thoroughly. Okay. Exceptions are that rule is that offenses can't a person can't be convicted without guilty mind, but exception is that a person can be convicted even without guilty mind. A person can be convicted even without guilty mind. Third example here, the sale etc of obscene books. It means selling of obscene book under section 292. First exception is that, wait 1 minute. If anyone feel uncomfortable, you can ask any questions, okay? Because it is the starting time. There is no any hurdle. You can ask, I will reply. Because I am teaching you, but you are unable to understand what is the purpose of my teaching. Okay, that's why anytime you can ask. But be careful. I will never allow you to make much more argument. You can ask only the answer. And other is that once a student asks, other students will not reply, because in this class only
Hello.
one person is boss and that person is mine. क्लास का सिर्फ अकेला ही बॉस है और
Sir,
हाँ बोलो.
sir, I have a question.
Yes.
Sir, what is the basic objectivity of IPC?
What is the basic objectivity?
Yes, sir.
Objective. Okay. I one line I want to inform. I am going to share, but whatever I am teaching, at that time you ask one questions only related to that topic. Okay, because we are I am starting point. If you feel any uncomfortable in this topic, you may ask. But my reply for one line, because you have asked the first time, my reply is that main objective of IPC is to prevent commission of crime and to maintain peace and tranquility in the society. This is the main objective of the IPC. Okay, come to the
Okay,
point.
sir.
You may ask related to the topic. Here, the first exception is that selling of obscene book etc. Section 292 of the IPC. As you know that here I was discussing the Ranjit Dev Udaisi versus State of Maharashtra. This is the landmark judgment. When it was decided on the August 1964. Be careful in the semester exam. If any students write the answer without following the chronology, I will not give much more marks. My point is that even if you are not following the chronology, please remember date of the judgment, date of the decision. So my point is that don't remember only to the Ranjit Dev Udaisi versus State of Maharashtra. At the same time, you have to remember that this case was decided on the 19th August 1964. Both the things must be remembered. And third is that on which particular section this case is based. It means in this particular case, which section was discussed. So here you can cite that section 292 of the IPC, which deals selling of the obscene books etc. Section 292 was disputed, was controversial in the in the case of Ranjit D. Udaisi versus State of Maharashtra. What happened in that case? In that case, dispute was regarding selling of Lady Chatterley's Lover book. एक book है, name of the book is that Lady Chatterley's Lover. मतलब लेडीज है, उसका नाम चटरली है, उसके लवर की ये स्टोरी है. The name of the title of the book was that Lady Chatterley's Lover book. Although he had no knowledge of this book, although he was selling, there was actors yes, but that was without knowledge, without guilty mind. The court held that Section 292 of the IPC, unlike several other sections, did not contain the words knowledge, negligence, etc. So, in this case, principle of strict liability was applied. Whenever I say principle of strict liability, it means those situations when liability is strict. It means those situations in which persons are convicted without guilty mind. Liability and strict liability. Whenever I use the he was liable, it means in that circumstances, actus reus and mens rea both were required. But whenever I say that, in that case, strict liability was imposed, it means person was convicted only on the basis of actus reus, even in absence of mens rea. Come to the other point. Sexual harassment, section 354A. Even this example you can't find out in any book. Sexual harassment, if you read the sexual harassment, you can read yourself. If you read any bare provisions and you are not getting the words either intention or knowledge or reason to believe voluntarily, negligently, rationally, in that case, in case you can say that here principle of strict liability will be applied. But be careful, I will give much more idea later on. Sexual harassment, if you read the section 354, because at time of the imposing the strict liability, object of the statutes always observed. So here, what was the main object of this inserting the sexual harassment provision under the IPC? Main object was that to prevent right to privacy of women, to prevent right to life of the woman. You can say that, sir, how can you correlate sexual harassment to Article 19, Article 21 of the Constitution of India? As you know that right to life means right to life includes dignified life. Someone is making the sexual harassment of a woman, whether he is interpreting in the right to life of that woman or not. Of course, my point is that sexual harassment was inserted to protect right to life, right to liberty, right to privacy of a woman. That's why if law is silent in such cases, strict liability must be applied. For example, other exception is that kidnapping from unlawful guardians, section 361. I will discuss all these cases later on, but this is another case in which principle of strict liability was applied. Landmark judgment is that R versus Prince, which who had decided this case? Honorable Justice Blackburn had decided the case. As you know that in the law of torts, when you will read, you have to read strict liability and absolute liability. In the strict liability, you have to read Rylance versus Fletcher case, which was decided in 1868. That case had also been decided by Honorable Justice Blackburn. It means you have to remember name of the case, year of the case, provision, name of the judge. Then you will get good marks. If you remember only R versus Prince case, then you will get only few marks. And once you are not getting 60% marks, your future will be much more darker. So that's why in that case, R versus Prince case, I will discuss later on in detail. But situation was that in this case there was a two person. There was one girl and other was the boy. Both had fallen in love of each other. What happened? One day both ran away from the house. Father of the girl filed a case against the prince, against the boy for kidnapping for abduction of that girl. Boy took the plea, Millards. I accept that her age in the document is below the age of 16 years. But she appears more than 16 years. Earlier age was 16 years. ठीक ना? बाद में उसको 18 ईयर किया गया. Earlier age was 16 year, later on age was the 18 year. That is the other. It means R versus Prince. Prince was arguing, Millards, I accept that whatever document had been produced regarding her age, that is the real. But by looking, she was looking more than 16 years. It means she was looking the mature. That's why I went with her without guilty mind. उसे लगा कि भाई लड़की की उम्र 18 साल 16 साल से ज्यादा है. थोड़ा बहुत हिंदी चल सकता है, इतना भी कुछ नहीं है. बट आई वॉन्ट टू इन्फॉर्म दैट वाट एवर आई एम स्पीकिंग द हिंदी, दैट इज नथिंग डिफरेंट फ्रॉम द इंग्लिश. तो वाट एवर आई स्पीक इंग्लिश हिंदी, प्लीज वेट एंड कीप पेशेंस. आई विल नॉट डिस्टर्ब एनीवन. कम टू द पॉइंट. उसे लगा आर वर्सेस प्रिंस के केस में लड़का का कहना था, वाज सेइंग मिलार्ड्स सी वाज लुकिंग, उसकी उम्र देखने में 18-16 साल से ज्यादा लग रही थी और हमें लगा कि वो मैच्योर है. और मैंने उसके साथ विद गुड फेथ में, और मैंने उससे पूछा कि भाई तुम्हारी उम्र कितनी है. उसने बताया कि हमारी उम्र इतनी है. मतलब उसने झूठ लड़की ने बोल दिया, मतलब कि लड़के से ब्लाइंडली प्यार करती थी. और वो दोनों चले गए. तो लड़का कहा कि मिलार्ड्स आई वाज what was the reply of the prince. Prince was saying that Millards, whatever I did in good faith, and even I asked age of that girl. She replied that she had attended the age of the maturity. That's why he did without guilty mind. But Justice Blackburn rejected this argument, and he said that in such cases, if law does not demand actus reus, judges can't insert such guilty mind. It means Justice Blackburn said that if law does not demand the guilty minds, law does not talks about requirement of the intention knowledge, the judges can't insert the such law. Because according to Blackburn, judges can only interpret the law, judges can't make the law. He said that if section 55 of this British Act does not require that person must do with the guilty mind, I can't borrow this condition. So Prince was convicted for his activities even without guilty mind. So this is the important point. It is the third exception. You can write in detail. Another exception is that bigamy. In the bigamy, as you know that in the British case, there is R versus Tolson. In that case, that lady was not convicted, but that is the judgment of the British court. We are not bound by the judgment of British court, but under section 294 of the IPC, which deals bigamy. In that case, court clearly said, in that case, you can read the word, and wording of this section doesn't require guilty mind like this. So this is the another exception of actus non facit reum nisi means citria. Economic offences. As you know that in that point there is another. This is the another fifth exception of the actus non facit reum nisi means citria. This exception was thoroughly discussed in the case of State of Maharashtra versus M.H. George. Although this case had been mentioned in your syllabus, normally teachers starts from this topic. They teach from the State of Maharashtra versus M.H. George. But as you know that I am teaching not to complete your syllabus. I am teaching for your competitive exam and other purposes. That's why we are discussing all these things thoroughly. I will discuss this particular case later on in very detail when I will start the classes another way. So here another exception in economic offences, honorable justice. In this case, majority opinion. There was a full bench. As you know that single bench, one judge. Division bench, two judge. Full bench, three judge. Constitutional bench, 5 judges or more than 5 judges. This case was decided by the full bench. Full bench judgment was decided by majority opinion was written by the Iyengar, minority opinion was written by the Subba Rao. So here majority opinion was that in such cases principle of actus non facere should not be applied. Otherwise a person may destroy economy of the country and tomorrow he may say that Millards, whatever I did without any guilty mind. In that case, person M. George came India with 34 kg gold. He came in India with how many kg gold? 34 kg golds without taking permission of the India. Tomorrow he was saying that Millards, I was very innocent person. I was not knowing that I can't go in India without the permission with these 34 kg golds. Do you know what would be happened? 34 kg gold is not simple things. Tomorrow another person can come 100 kg golds and he can destroy the whole economic of the country within few hours. Honorable Justice Iyengar said that in such cases, doctrine of actus non facit reum nisi mens rea can't be applied. Otherwise, in case of requirement of actus reus plus mens rea, a person can escape. Tomorrow he can take the defense, Millards, whatever he did without the guilty mind. And in such a way, he can destroy the economy of the whole country. That's why in such cases, principle of strict liability was applied. Public health. As you know that even in the public health, principle of strict liability is followed. Do you know what would be happened? Do you know whenever you go to the market, it is clearly written that expiry date. It is clearly written MRP expiry date. Do you know? Before some days, Indian government took a good decisions. It had also clearly mentioned that in case of selling of the sweets, every shopkeepers have clearly mentioned that expiry date of that sweets. Expiry date of that sweets. So my point is that in this case, point is that if any person is doing business of the food, doing business of the grain, he will be liable even without his guilty mind, because if you apply in such cases, tomorrow he can say that Millards, whatever I was selling, I was not knowing content of that liquor. I was not knowing whether in that packet there was a charas gaja like this. I thought that is a simple powder. What would be happen? He can destroy young age, he can destroy youth, he can destroy the economic of the country. That's why in such cases principle of actus non facere can't be applied. In such cases principle of strict liability is applied. देखें क्लास चल रहा है कि लिफ्ट हो गया इस क्लास but all of you are only 54 present. Okay, in one day I did not take class. First, second day, everyone approached, but tomorrow all of you are missing here. Be careful, otherwise once I will take actions, all of you will feel uncomfortable. Okay, जियो और जीने दो, ठीक ना? In the next class, please inform your friends and enjoy the class. Here the public health, that is the point here, is that in the case of Pyaralit K. Tajena versus Mahadev Ramchandra Dange and others, Honorable Supreme Court said that in case of tried law, in that law in which it is presumed, it is common sense that everyone knows the law. It means it clearly says that in case of food, no one can't be allowed to escape from the law only on the basis that he was not knowing content of that things. In the case of state of Madhya Pradesh versus Narayan Singh, Honorable Supreme Court also said that in the if any matters come under the Food Safety and come under the Essential Commodities Act, he will be punished even without guilty mind. These are the some exceptional cases in the basis of which a person can be convicted even without guilty mind. So my point is that if anyone asks you, please write the answer. That is the, for example, actus reus non facit reum nisi mensit rea and its exception. First of all, you have to define literal meaning of this maxim. Literal meaning of this maxim with the help of Lord Kenyon. Later on, you will discuss what would be jurisprudential point, what would be effect if maxim would be applied. You can say that if maxim would be applied, it will be benefit for the accused. Why benefit for the accused? Because prosecutor, as you know that in the criminal jurisprudence, it is settled principle that an accused is presumed innocence unless and until it is proved that he is guilty. In that case, in this maxim, prosecutor is bound to prove actus reus as well as mens rea. Once you say that please prove the two things, in that case, proving the guilty mind is a very difficult thing, and in such cases, it goes to the benefit for the accused. But once this maxim would not be applied, it means prosecutor is not proved to guilty mind. Prosecutor is not proved to guilty mind. Prosecutor will be bound only to prove the actus reus. In that case, there is a requirement of only one things. In that case, it will be against accused because in second chance there is much more chance that the accused person will be convicted. Come to the exceptions. Meaning of this exception is that, as you know that here I have written here about 13 exceptions. You can write in detail all these exceptions. Whenever I will discuss the rape like this, you can discuss like that point. Here I have written some situations in detail. You can write in detail. Here sale of books, sexual harassment, kidnapping, rape. You can insert the rape here also. A man is said to commit rape if he makes sexual intercourse like this point is that keeping by gaming. Okay, economic offenses, you can cite them in George case. Here was the R versus Prince case. Here you can discuss Ranjit Du, Udaisi cases. All these cases you can discuss. Okay, come to the another point. School of mens rea. Not in the school of mens rea.
Sir,
हाँ बोलो.
sir, is there any difference between crime and offense?
Yes, there is a difference between crime and offense. But do you know what happened in that particular case? Once you try to search meaning of the crime and offense, once you try to search what is the meaning of difference between crime and offense, do you know what happened? I tried several times these answers, but what happened when I tried? Even the several jurists, they never tried to make difference between the crime and offense. Sometimes they write the crime, sometimes they write the offense as a parallel. As a parallel. In the starting class, I was saying you, but I will tell you difference. Keep patience. Because I am teacher, you are students, I have to reply. In the previous class, when I was discussing the definition of the crime. I did not discuss the definition of the offense. Whatever I cited in the first class, that is the Bentham, Austin, Stephen, whatever I discussed, here I discussed meaning of the crime. I never discussed the meaning of the offense. Do you know why and how and what are the difference? Come to the point here is that word crime has not been defined under the Indian Penal Code. What is the meaning of the crime? Crime word had not been defined under the Indian Penal Code. But offense word had been defined under section 40, under section 40 of the Indian Penal Code. One thing, offense word had also been defined under section 2 clause N of CRPC. But crime word had also not been defined under the CRPC. So my point is that in Indian law, offense word had been defined several places, but crime word had not been defined in several places. So what happened? What would be effect of this? 1 minute. See the difference between the definition of the asking, then I will proceed further. Stephen defined the crime. He said that crime is an act forbidden by law. On this point, no problem. On this point, offense and crime both are same things. But once he takes second part, he said that which is at the same time revolting the moral sentiment of the society. He is saying that he also includes in the crime, he also includes moral sentiments of the society. But in the offense, offense does not include moral sentiment of the society. Offense does not include moral sentiment of the society. I want to give one example. I want to give one example. Suppose that you are good swimmer. बहुत ही अच्छा तैराक हो आप. Suppose that you are a good swimmer, but you are ordinary person. You are ordinary persons. You are sitting on the bank of the river. You are enjoying life, whatever is that. One person is drowning in the river. एक वर्ड मैं बोल नहीं पा रहा हूँ, वो डूब रहा था. उसको क्या बोलोगे? मतलब ड्राउनिंग क्या बोलेंगे उसको आप लोग?
Sir, drowning.
Drowning.
Sir, drowning.
Drowning. Yes, yes, yes. So my point is that one person was drowning into the river. You are seeing, you know that you can save him. You have capacity, you can save him. But you did not save him. Other persons are requesting, please go, please save him, save him, save him. God will bless you like this. But you did nothing. You did nothing. Although that was again the moral sentiment of the society. That was again the moral sentiment of the society. But whether tomorrow can you be prosecuted for not saving that persons? No, you can't be prosecuted because you are not the police officer authorized for that purpose. You are not the authorized person to save. Law does not impose duty upon you to save that person. That's why, although that is the crime, but that is not the offense. Offense is that if you read the section 40, section 40. मैं क्लास ले रहा हूँ, कॉल करूंगा आपको. ठीक है, नमस्कार. So my point is that here the offense clearly said that for the application of the offense, if I say the offense, it means offense is a codified. All the ingredient of that section must be covered. Even a single ingredient is missing, that will not be an offense, but that will be crime. So my point is that offense, whenever I use the word offense, that is the codified law. That imposes some duties over, law imposes some duties over the person. But whenever we use the word crime, it includes codified law as well as moral sentiment of the society. My point is that offense word is narrower, crime word is wider. If I said that, please do this, you had committed a crime, God will punish you. So my point is that in these situations, when you did not save that person, you did not commit the crime, but although you had committed you did not commit the offense, but although you had committed the crime. I hope that all of you have get the difference between the crime and offense. समझ में आया कि नहीं भाई?
Yes, sir.
Yes, sir. Yes, sir.
Yes, sir.
So my point is that whenever we use the word offense, that is a codified law, and that has imposed duty upon you. Whenever I will teach to later on main body, At that time, I will quote you. This problem is always asked in the competitive exam. People become emotional. Oh, he was a good swimmer. Why he did not save him? He can do, he could do, but he did not do. He must be punished. Why he must be punished? Are you getting my points? It was not his duty. You can't.
means sir, act against humanity is not its crime.
No, you can't say in this way because some act against humanity had been codified and some act against humanity had not been codified. All offenses against humanity can't be said that that is the offense. Are you getting your points? For the example,
Yes, yes, sir.
leave it. For the example, what happened in the initial stage? Fundamental rights and DPSP were both different things. But later on, due to the development, some DPSP were declared as a fundamental rights. My point is that in the future, although whatever today is a crime, tomorrow may be the offense. So this is the basic points I am going to discuss further. ठीक ना? Proceed. If in the interview, if anyone asks you, so what is the difference between, man, I will make the chart and I will send by making the difference between crime and offense later on. Okay, come to the point. It is a very good question. Everyone know. At least a student of Delhi University must know, and especially my student. मजा ले लेता हूँ. Let's come to the point here. School of Mensaria. This is the other points. This is the much more important points. अब time है ना हम लोगों को discuss करने का. I think I have time.
3 minutes. 3 minutes.
Yes, sir.
Uh, regarding these points, yes, tomorrow I want to start from this topic, school of this class. Even if anyone have a questions, please may ask you. Okay, I want to ask some questions. What are you doing? Okay. Sanchit.
Yes, sir.
Okay, let me know what is the meaning of external facility region Nisimensitia.
The act itself not guilty unless it is done by guilty mind.
Yes, very excellent person. Sumit.
Yes, sir.
Let me know what would be effect if this doctrine would not be applied.
What, sir?
So this,
जिससे क्वेश्चन पूछूंगा वही आंसर देगा. Okay, Sumit, I am asking that what would be effect if this maxim would not be applied?
sir, if this maxim is not applied, then benefit is for victim.
Yes.
बेनिफिट मिल जाए, विक्टिम को बेनिफिट मिलेगा सर इससे.
No, you have to say that first. How to reply in the interview? You have to say that respected sir. There is no need to say respected. I am another person, but you have to say that respected sir. First effect is that you have to say that sir, actus non facit reum nisi mensitria means act committed with guilty mind. If this maxim would not be applied, in that case, there will be no requirement of the guilty mind. First effect is that wherever this maxim will be applied, in that case, there will be no requirement of the guilty mind. And consequently, if there will be no requirement of the guilty mind, it means it will be easy for the prosecutor to prove the actus reus, and it will be difficult for the accused to disprove the mens rea. In this way, each and everything, all of you have replied in a very proper manner. Thanks. We will meet tomorrow. Be careful. Attendance of all of you are recorded automatically at the two place, at my place as well as at the DUCC. Thanks everyone.
Thank you, sir.